Hello everybody, and welcome to our webinar on how franchisors can avoid misleading and deceptive conduct. Obviously a really important topic for franchisors, being one of the most litigated provisions in the context of franchise disputes. So I applaud everybody for coming along today to learn a little bit more about the topic. My name's Emma Jervis. I head the franchising and leasing team at LegalVision. I'm joined today by the lovely Beck, who heads our dispute resolution practice group. Now, before we begin, just a couple of brief housekeeping matters. Firstly, you'll be emailed a copy of this webinar recording. Please feel free to share it amongst your friends and colleagues. You should see at the bottom of your screen a chat box. If you have any questions that arise during the webinar, please feel free to pop them in that box and we'll have a Q&A session at the end. You'll also be emailed a survey after completion of the webinar, and it would be greatly appreciated if you could complete that. I'll now hand over to my colleague Beck to introduce herself and kick off the webinar.
Thanks, Emma. So my name's Rebecca Ward and I'm the practice group leader of the disputes and regulatory team here at LegalVision. Have a lot of experience in dealing with consumer law complaints, and so very happy to talk about misleading and deceptive conduct. We're just as a brief overview of what our presentation is going to involve. I'm going to start with a general introduction into misleading and deceptive conduct. We'll talk about the consequences of when you may have engaged in misleading or deceptive conduct, and specifically the reasons why misleading and deceptive conduct claims do arise in franchise disputes. Emma's going to run us through some examples of some interesting case law, and then we're going to talk about some practical tips, how you can run a misleading and deceptive conduct check to make sure that you're may not be engaging in this sort of conduct, and if you do face a claim, how you can handle allegations. We're going to follow up with a Q&A session, so that's your opportunity to ask us questions that you might have. And then we're going to talk about briefly our LV Pro membership. Great, so let's just launch straight into it. What is misleading and deceptive conduct? Well, Section 18 of the Australian Consumer Law says that a person must not, in trade or commerce, engage in conduct that is likely to be misleading or deceptive, is misleading or deceptive, or is likely to mislead or deceive. So what does that mean? Well, let's break that down. So the elements of a particular claim is that a person has engaged in conduct. So in the case of a franchise or a dispute, it's normally the franchisor that's alleged to have engaged in conduct. And the conduct in question would be entering into perhaps a franchise agreement with the franchisee. What is considered conduct in terms of trade or commerce is quite broad. And in terms of the franchise agreement, it could be, for example, representations or statements that have been made prior to the entry of a franchise agreement or during the conduct of the agreement, acting in a particular way, making implied representation. So it may be that some sort of outcome or promise was indicated by some sort of conduct. It's also interesting that silence or omissions can also be misleading and deceptive conduct. So it might be not saying something or leaving some key information out in terms of negotiating a franchise agreement. And in terms of whether or not the conduct is actually misleading or deceptive, well, it has to be viewed, it's generally a case-by-case assessment. And it's come to a conclusion looking at all of the circumstances. So what you would have to look at is, would a reasonable person in the same position of the franchisee have considered that conduct misleading or deceptive? Is generally the test that would be applied. So who bears the burden of proving a claim? Well, the person that's making a claim that you or a franchisor has engaged in misleading and deceptive conduct is responsible for providing the evidence to support that claim. So that means that they have to demonstrate that the conduct was misleading or deceptive or likely to mislead and deceive, and that they've relied on those representations to their own detriment. However, if the claim involves future representation, so for example, a representation made about a future event, so for example, this will happen in the future if you enter into this agreement, the burden flips. So that means that if that allegation has been made, it would be up to the franchisor to demonstrate that at the time that that representation was made, it was reasonable at that time period. So there can be some nuances about who has to prove what. So it's really important to get some good legal advice. It's also important to note that there are similar misleading and deceptive provisions in other legislation. For example, the various state-by-state Retail Leases Act. So as an example, the New South Wales Retail Leasing Act, specifically sections 62 and 62D and 62E, provide that a party to a retail shop lease must not engage in conduct that is misleading or deceptive to another party to a lease, or that is likely to mislead or deceive. And a party who suffers due to the latter conduct may recover the amount of loss or damage. So it's important to note that there are various types of claims that can be made. Now I'm just going to hand over to Emma now, thanks.
Thanks, Beck. I'm just going to explore what the consequences are if there is a finding of misleading and deceptive conduct. The big one people obviously think of is an award of damages. Now, damages, the purpose of damages is to, in essence, right the wrong or compensate the franchisee for the losses occasioned as a result of the conduct. Now, in order to obtain an award of damages arising from misleading and deceptive conduct, it's necessary to show that the loss and damage was suffered because of the conduct. And that brings into play the legal concept of causation. Taking that one step further, the case of Bartlett versus Weatherall confirmed that even if you've relied on misleading representations, you won't be entitled to damages unless you can show that you could have and would have done something different had the misleading statements, for example, not been made. How that's commonly pled in the context of court proceedings is a franchisee will argue that had the misrepresentations not been made, they never would have entered into the franchise agreement. It's then up to the court to make an assessment as to the truth of that statement. And there are a number of cases that have run all the way to trial where a court has said, yes, there was a misleading statement, but you still would have entered into the franchise agreement, and therefore the franchisee is not entitled to an award of damages. Then looking at the precise dollar figure, on that example of I would never have entered into a franchise agreement, the award of damages is typically what's called a no transaction award. A no transaction case arises when a plaintiff asserts that they wouldn't have entered into a transaction, here the franchise agreement, but for the acts or omission of the defendant. And the dollars involved will be the sum required to place the misled party in the position they would have been had they not engaged in the loss-making transaction, i.e. had never entered into the franchise agreement. In the context of franchising, where fees can be significant, this can result in a very significant award of damages that can include, for example, refund of all franchise fees paid, payment of any loss occasioned in running the franchise business, payment of expenses such as fit out, for example, as well as other ancillary costs incurred by the franchisee. We'll talk towards the end about some of the awards of damages that have been awarded in actual case law. Now, looking at another consequence is that with respect to the ACCC. The ACCC is obviously the regulatory body that monitors compliance with the Australian consumer law, which includes the code and the misleading and deceptive conduct provisions. The ACCC has really wide powers. It can investigate, it can accept court enforceable undertakings, it can issue infringement notices, and it can even prosecute franchisors through the courts. In particular, we're seeing a lot of cases prosecuted by the ACCC in the Federal Court of Australia. The ACCC has publicly stated in recent years that the franchise sector is an area of focus, and we're actually seeing that in the number of cases being commenced and investigations being undertaken. So it's really important that franchisors keep in mind those powers of the ACCC and comply with any investigation that the ACCC undertakes. The final consequence I wanted to talk about was with respect to disclosure. The disclosure document requires the disclosure of court proceedings and further to the code amendments made last year, even now mediations. That disclosure extends beyond the mere existence of the court proceedings, but also requires a franchisor to set out the status, the nature of the claims, and the outcome. Now, obviously, franchisors generally want to avoid having to disclose that they were sued for misleading and deceptive conduct by a franchisee, or that they were prosecuted by the ACCC, which should provide an extra motivation for avoiding such claims being made. This is particularly the case when franchisors consider the upcoming franchisor disclosure register requirements, which will make this information public. As I said at the start, claims of misleading and deceptive conduct are really, really common in the context of franchising. And I'm just going to hand over to Beck to delve a little bit further into why that might be so.
Thanks, Emma. So franchise by its nature is very document heavy. It's highly regulated and there's a lot of information exchanged in the pre-contractual phase. So it's really important to have a look at the documents that you're handing over to potential franchisees. The quality of the documentation that's supplied, it's really important to make sure that there's nothing in the documentation that's incorrect or could be misleading and deceptive. All franchise should be really wary about the content of their disclosure documents. It's really important to make sure that it's accurate, it's up to date throughout the year where there are materially relevant facts. So keeping an eye on the documents to make sure that they're all relevant and factual is really important. It's also really important to consider the way that financial data is being presented. We often see a lot of claims arising out of allegations that the financial data was presented in a very misleading or deceptive way. We know that financial data would be presented in such a way that would be aimed to entice potential franchisees into an agreement. But it's really important to make sure that it's accurate and, for example, not make any guarantees about the potential performance about a franchisee's business. For example, being selective about particular data could lead to a view that the financial performance of the franchise network is profitable than not, for example. Finally, we see a lot of claims come under the consumer law because it provides an option or an avenue to make a claim that doesn't necessarily rest on a breach of the particular term of a franchise agreement. And it gives the claimant an option to pursue a claim through multiple channels, i.e. they've got an option to go to court, they can follow the dispute resolution process provided by the franchise code, or make a complaint to the ACCC. The code, as we know, has a very prescriptive dispute resolution process that's very accessible and relatively cheap. Franchisees can also collectively agitate a common dispute, so that can give more leverage to the claim and help reducing costs as well. Also, by making a complaint to the ACCC will take over investigative actions, and it's an obvious benefit to a complainant because they don't have to expend any costs in pursuing that as an option. Now, Emma's going to talk about some cases that have actually made their way to court together with some ACCC findings.
Thanks, Beck. There are a heap of cases available that demonstrate franchise or misleading and deceptive conduct. I've chosen just a few. The first one I'm going to talk about is Khazarian versus Blow Dry Bar. This was a 2015 decision. Here, the franchisee in pre-contract discussions was assured by the franchisor that it had, by 2012, already established 16 profitable niche cash flow positive salons. Now, that statement's obviously quite general in nature, an overarching statement, if you will, but the court still deemed it misleading, where the franchisor knew at the time of making that statement that some of its salons were actually really struggling and not breaking even. The lesson here is that even high level and broad statements can be deemed misleading and should be avoided in your sales pitch. Another lesson, perhaps, is the ultimate outcome. Here the franchisor went broke. They went into liquidation and they could not afford to pay the damages award, which was around 700 grand. This is something we see a lot. Franchisors are subject to significant damages awards, but can't pay them in fact because it's more than they can afford. The next case I'm going to talk about is that of Gerges versus Michelle's Patisserie. This was where representations were made not about a financial aspect of the business, but about the product quality. And the franchisor made assurances that the product quality would be maintained, where they were going to be shipped snapped frozen from Brisbane to Townsville and arrive in a saleable state. The franchisor, it was found on appeal, had no reasonable basis to make those claims about the products where they had concerns about the ability of a specific bakery to supply future goods in the future. Now, importantly in that case, the franchisor's defence rested very heavily on the fact that the franchisee had signed a deed of prior representations and a questionnaire by which they basically signed off on the fact that they were not relying on any statements external to the franchise agreement, i.e. they didn't include in the deed of prior reps, which is now a common document in the context of franchising, anything about these statements about the product quality. Notwithstanding that they had failed to include this, the court found that the misleading and deceptive conduct had occurred, in fact, been relied upon and caused damage. The lesson here is that franchisors should be wary that including warranties, including disclaimers and entire agreement clauses, and having these deeds of prior reps in place, while a wonderful step and something us lawyers love, it's not conclusive. It doesn't mean a claim of misleading and deceptive conduct can't be successful. It's just one piece of evidence that the court's going to look at in assessing the entirety of the claim. The next one I'm going to talk about is RFG Group. For obvious reasons, it would be remiss of me to discuss misleading and deceptive conduct in the context of franchising without talking about RFG Group. RFG Group, one of the largest franchisor groups in Australia. They own Michelle's Patisserie, Capers Pizzeria, My Favourite Donut King, a raft of other brands. The case that's currently before the federal court follows pretty scathing findings against RFG in the Parliamentary Committee Report Fairness in Franchising. It's an ongoing case, so it doesn't have a conclusion yet, but in essence, it's the response, if you will, of the ACCC to findings in that report. In that report, there was actually an entire chapter dedicated to a case study that was RFG. In circumstances where the committee found the operations of RFG illuminated many of the issues identified in franchising. Relevant to misleading and deceptive conduct, the report found that RFG had a practice of what's called churning. This is where a franchisee fails. The site is then operated for a brief period as a corporate store, then sold to a new franchisee until they too fail and the cycle continues. The benefit to the franchisee law here is obvious, that they get numerous initial franchise fees for the same site. The ACCC has initiated, as I said, this action in the federal court concerning the sale of 42 corporately operated businesses which were sold to franchises. The ACCC, in commencing those proceedings in its media release, has said that we allege that Retail Food Group withheld critical profit and loss information about these corporate stores from incoming franchisees and falsely represented that these loss-making stores were viable or profitable. Given the number of franchises involved, given the size of RFG, this will likely, if there is a finding of misleading and deceptive conduct, be a record-breaking case with respect to penalties. So we will be watching that one very, very closely. Now, talking of penalties, I think it's important for franchisors to be aware of the dollars that can be involved where there is a penalty issued against them following a finding of misleading and deceptive conduct. Just going to run through a couple very quickly. Firstly, with respect to the GeoWash franchise, here the franchisor made misleading statements about how franchise fees were applied, but also the existence of relationships with third parties like car manufacturers, for example. Following a finding of misleading and deceptive conduct, a penalty of $4.2 million was handed down, but importantly, of that, over $1 million was a penalty issued against an individual director. I think what that really shows is that directors should not assume that their corporate franchise structure protects them from vulnerability for a claim of misleading and deceptive conduct. The next case I want to talk about briefly is MegaSave, where there was a $1.9 million penalty issued, where the franchisor misled prospective franchisees as to weekly minimum incomes, guaranteed annual incomes, things like that, where there was just no reasonable basis for saying what they said. To me, the interesting part of the decision here was that the court ordered that the franchisor restrain for a period of 5 years from entering into another franchise agreement unless MegaSave actually provided a copy of the court judgment to the prospective franchisee at least 14 days before they entered into the franchise agreement. Obviously something that would dissuade a lot of people from entering into a franchise agreement. And just an interesting example of the sort of orders that can be made. Talking about big bucks, we had last year the decision against Jump Swim School called Swim Loops, where the penalty was $23 million. That followed the franchisor falsely representing to 174 franchisees that they would have an operational swim school within 12 months of signing the franchise agreement, which statement they were found to have no reasonable basis for making, where in fact only a very small percentage of their franchisees ever actually had a pool built. There were some pretty damning comments in the decision, which would likely justify why those big figures, the $23 million penalty, was imposed. Just to quote Justice O'Brien, while Jump Loop's conduct cannot be described as fraudulent, it was deliberate in the sense that Jump Loops was aware that it could not deliver on its promises, but continued to entice persons to enter into franchise agreements and take payments from them. So yeah, some quick examples of the nature of misleading and deceptive conduct claims and also the penalties that can be issued. So how can you avoid being faced with an allegation? I'll hand over to Beck for some practical tips.
Thanks, Emma. So we've put together a checklist of some things that franchisors can do to help avoid engaging in misleading and deceptive conduct. So manage your teams. Train your team members on what is misleading and deceptive conduct. Make sure all your team members are aware of the consequences of engaging in misleading and deceptive conduct. Consider providing your team members with a sales script or some other directions on how to respond to questions from prospective franchisees that could give rise to misleading and deceptive conduct claims. And prepare file notes or keep records of conversations with franchisees and review or audit these records regularly. These could be really important evidentiary documents in the event that a claim is made. Consider your website and social media. A lot of claims come out of misleading and deceptive advertising. So regularly audit your website and social media channels to ensure that all information is accurate and up to date. Ensure that your website contains terms and conditions and appropriate disclaimers where necessary. Have a lawyer review your website and social media channel to ensure that they're compliant and raise no legal issues. And perhaps consider ensuring that a lawyer reviews all of your promotional material. Consider your sales tools. Review all sales material and ensure that it does not contain any misleading or deceptive representations. Consider getting a lawyer to review the sales material that you provide. Don't just assume that bold or grandiose statements will be deemed puffery. Get advice. Only make promises that in your sales material that you're in a position to fulfill. If you are providing financial information in relation to profitability, revenue, or otherwise, ensure that those figures are regularly audited and up to date. Provide appropriate disclaimers of sales and figures. Ensure the information is attached to the disclosure document in accordance with the code. And if you provide information from other sources, make sure that there are appropriate disclaimers. And finally, consider your disclosure documents and other ancillary documents. Regularly review your disclosure document to ensure it's up to date and correct. You should do this annually. Update your disclosure documents as changes occur in the system. Keep an ongoing ledger of the changes that have been implemented from year to year. Again, this can be really important information if a claim is made. Ensure all information relevant to the franchisee's running is in your disclosure document. Ensure all figures in the disclosure document are accurate, exhaustive, and up to date. Audit these figures against bookkeeping data and use ranges for certain expenditures or costs where the amount may not be fixed. Put in place the proper documentation to exclude pre-contractual warranties. Make sure that this is signed concurrently with the franchise agreement. And if the financial information or disclosure is provided, use appropriate disclaimers. So what happens if you actually get a claim? Well, Emma's going to talk to you about how to deal with a claim of misleading and deceptive conduct.
Thanks, Beck. So if you are faced with a claim, and typically that will be expressed either in a formal notice of dispute issued in accordance with the code, or it can even just be a general letter of demand, the first thing to do is to understand what is being alleged. Us lawyers will never respond to a vague allegation, and you should neither. Get what we call the particulars of the claim, the who, the what, the when, the where, and the how of exactly what was alleged to have been said or done, and how it was deemed to be misleading. Once you have that information, you should then make an assessment of the validity of the claim. This is both a factual and a legal exercise and can involve, for example, talking to persons from relevant departments in your team, reviewing all of the pre-contract conversations with the specific franchisee, looking at what your franchise agreement says about a specific topic, and basically looking at everything and talking to everybody involved. You should also at this stage be looking for anything which may contradict what is being claimed. For example, an email from the franchisee expressing their unequivocal intention to enter into the franchise agreement made after the relevant steps. Then you should revisit the code and your documents to make sure that you're complying with both your legislative obligations, i.e. those in the code, and your contractual obligations, i.e. those in your franchise agreement. You should also make sure everything's signed. There's no point, for example, having a deed of prior reps if it hasn't been signed by a franchisee. Next, obviously, obtain legal advice. And I'm not just saying this because I'm a lawyer. A lawyer worth their paycheck, once you've given them all of the relevant information, will be able to provide you with advice as to your vulnerability under the claim and help determine a strategy to best deal with the claim. You should be communicating with the franchisee that has advanced this claim. The worst thing you can do is stick your head in the sand. If you're investigating the claim, let them know that, but just make sure any written communications on the subject matter are legally vetted. For example, certain things may want to be expressed without prejudice. You should, of course, adhere to the dispute resolution process in the code. Even if you think the claim has no merit, this is a prescriptive dispute resolution process, so refusing to go ahead with it is a breach of the code. And this is a much better way to resolve the claim than ending up as the named defendant in court proceedings. Finally, once it's all done and dusted and the claim has been resolved, learn from it, review your documents and processes, and update your system as necessary. Okay, I'll hand back over to Beck. Beck, we can't hear you.
Sorry about that. I've been sneezing so much, I muted myself. Our handy checklist that we ran through earlier, and a lot of this information is available in our guide, the Franchisor's Guide to Avoiding Misleading and Deceptive Conduct. So please download a copy, which is available to download in the handout section of your webinar panel. And for those of you that might be interested, we have these webinars quite frequently. Our next one coming up is called New Kid on the Block, on the blockchain, understanding the proposed laws for crypto, NFT, and blockchain projects. Very topical at the moment, recommend it. It's on Wednesday the 25th at 10 a.m. and you can register online using the link there. So it's just legalvision.com.au/events. Okay, now's the opportunity for you to ask us questions. So please submit your questions into the chat box in the panel, and we'll do our best to answer them. We've got one question that we can just get started with. So the question that's come through was to do with the powers of the ACCC to force franchisors to provide proper software. Emma, are you happy just to give an answer to this question?
Yeah, there's no specific legislative provision, for example, by which franchisors are obliged to provide specific software. But often the provision of proper software or specific software is incorporated in, for example, the undertakings or an agreement entered into with ACCC as a way to resolve an issue that they've identified. This is getting off misleading and deceptive conduct, but I know in the 7-Eleven scandal, part of the resolution to that scandal was an agreement entered into between the ACCC and the franchisor of the 7-Eleven franchise system, where they put in place proper software to monitor employee payments and compliance with processes and systems. So there is no specific power, but it's an often relied upon provision of an agreement or an undertaking entered into as a way of resolving an issue that the ACCC has identified. Any other questions, guys?
Well, while we're waiting for some questions to roll in, perhaps, Emma, can you talk about some of the things that come up? Like, what are the most frequent types of disputes that arise in terms of in misleading and deceptive conduct? Like, do you have some examples of some good issues that have arisen lately?
Yeah, heaps. So franchisors would be aware that the code updates last year included provisions whereby franchisees could, as a group, agitate disputes or grievances, and that seems to have resulted in a bit of a barrage of franchise disputes arising, where franchisees have been given a common sales pitch, for example, or given bundles of documents pre-contract that the franchisees allege contain misleading and deceptive statements. Those sorts of statements I have seen recently include statements by a franchisor with respect to the costings of a specific type of business. Those costings, however, excluded basically members of this particular business cancelling memberships or not paying, i.e. bad debt, and the franchisees allege, as the franchisor had operated corporate sites, they knew or ought to have known that excluding that statement meant that the bottom line was misleading. So that's just a practical example of one little omission on a document, ultimately resulting in a pretty substantial claim being made against a franchisor.
Okay, interesting. Okay, we've got a question. Can we talk about rebate disclosure requirements? Emma, is that something that you're happy to cover?
Look, it is. It's got not much to do with misleading and deceptive conduct. I guess failure to disclose a rebate would be misleading. So the code updates last year included provisions requiring franchisors to disclose the existence of any rebates that they receive, for example, from third-party suppliers or introducers, and also the aggregate percentage of the money that, or the quantum that they receive as a total of the sales or revenue generated by that third party. In the context of misleading and deceptive conduct, it could be misleading if that's not disclosed at all. And for example, it was later found that the motivator for the franchisor entering into the franchise agreement was the receipt of this rebate and not some other reason. So it's a specific requirement in the disclosure document that should be addressed completely.
Great, thanks, Emma. Look, we've got no other questions at the moment, but that doesn't mean that you can't bring up some questions later, and I'll talk about strategy sessions at the end. So just moving on to our next slide. Let's talk about potentially becoming an LV member. LegalVision has a great membership scheme. It's called LV Pro. It's quite unique in the market, and what it is a membership where you pay a fixed fee on a monthly basis. And you get access to our membership benefits, which is unlimited document drafting and review, legal advice consultations, quick turnarounds for legal work, and basically a full service offering. The benefit of LV Pro is that it gives you really good cost certainty. So you know how much you're going to be spending per month, so it really helps with budgeting, and you get all of the legal advice that you need to help run your business. Members can book in for unlimited consultations. Thanks. So you can request a complimentary consultation today. So webinar attendees are eligible to get a complimentary consultation to discuss how we can help with your franchise legal needs. If you've got a question that's arisen out of the presentation that you'd like some more information on, also a good opportunity to ask that question. So what you can do is book a complimentary consultation. It's an offer that's available to our webinar attendees. Leave your contact details in the survey that will appear after this webinar ends, and we can reach out to you to arrange that consultation. You can also email us at reply@legalvision.com.au and mention that you watched this webinar. Great, well that brings us to the end of our presentation. Thanks so much for joining us.
Thanks, guys.